Herkese selamlar. Bu videomuzda Amerika'da marka tescili yaparken bilmeniz gerekenlerden bahseden iki kişi var. Anton ve Onur. Biliyorsunuz Onur bizim ekip arkadaşımız.
Başladık mı? Konuşabiliyor muyuz? Bizi zorla tutuyorlar burada.
Anton'la kısa bir sohbet yaptılar. Amerika'da marka tescili yaparken yaşayacağınız süreç ve dikkat etmeniz gerekenlerden bahsettiler. Altyazılı bir video olacak. Şimdiden iyi seyirler, başlıyoruz. Oldu bence.
Evet, gayet güzel.
Hello again, Anton.
Hi.
I would like to ask you some questions that we got curious about. So the first question is, what should we consider when choosing a trademark name? What are your recommendations for the first-time trademark applicants?
Sure. So that's a really good question. And I get a lot of applicants who approach me with things that probably don't work. The two biggest things to consider are, first of all, don't do anything similar to a famous brand that you've already heard of. So anything too similar to a famous brand is really risky, not only because the government, which is the U.S. Patent and Trademark Office, might refuse your application, but also because famous brands are the most common to hire lawyers to file oppositions, or they can even file legal action. The other thing to keep in mind is a trademark, for it to work, it can't be just a generic term. So, for example, if you're selling, let's say, towels, you can't trademark the term cotton towels because that, if they are towels that are made of cotton, you can't have the exclusive rights to cotton towels. So you have to add some other element. So, for example, continuing with my example, this is an example I'll use for going through this. So say you have a trademark for towels. Well, cotton towels wouldn't work as a trademark, but you could do, say, Sun City, let's say. So here you have a term that it's related to the product because, you're creating this idea that maybe you'd want to use a towel, go on the beach when it's sunny, but it doesn't describe literally what the products are. Another thing a lot of people do is a lot of people do things with their name, and this can be done, but you have to be careful because if you try to trademark just your surname, so your last name, that can cause a problem. But a combination of your first name and your surname, or your middle name and your surname, or combining your surname with other words to create a new word, that's commonly done, and that can work. And that can actually be pretty good because that's likely to be what's called distinctive, which means that if you use something based on your own name, it's less likely that somebody else already has it, versus if you use something with very common terms, like, again, say for clothing, terms like fashion or beauty, things like that, then it's more likely that unless you combine them in some really new and interesting way, that somebody else already has something like that registered.
Actually, my next question is, how can you trademark a person's name, but you already explained, so I'm just skipping this one. So how long does a trademark application process take to be approved in the United States?
So this changes with time. It used to be a lot shorter and has been getting longer. And the government has been saying that they want to take it back to how it was, but so far that hasn't happened. Right now, it takes about 9 months to reach examination, which is when the government first looks at your application and goes through it and runs their own conflict search and also makes sure that it, comports to all their regulations. And then after that, there's a period called publication, which is when third parties, other people, can potentially oppose your application. And then if nobody opposes, and if you're already selling the product under the trademark in the United States, you get your registration. The full registration for a trademark that's filed under an in-use basis, meaning that you're already selling when you file, is over a year. It's about 13 months right now. Again, they're trying to reduce this time. About 2 to 3 years ago, it was 7 months to registration. So it was about half as long. But since COVID, this time has really gotten longer, and so far it's stayed at about 13 months to registration.
So the next question is, what should we consider in terms of not being rejected by other trademarks?
So again, the most obvious is just think of big brands that you know and just do a Google search. The USPTO, when they do their search, they search their own internal system. But their own internal system is difficult for somebody to search unless you have specialized software or a lot of experience in doing trademark searches. So this is something I can help you with. It's a major part of my service. But I've found that when clients do this search, oftentimes they make mistakes and they either don't find things or they find things that they think are risks that aren't risks, and it's not really worth it. However, Google search can be helpful because most, especially bigger companies, are going to have websites. So if you enter the trademark you're considering, and you immediately get a hit that there's already a company Now, again, you have to be careful, like, where are they? Are they in the United States, or are they in, Spain or China or wherever? But still, if you do a Google search and you see an immediate result, then maybe that there's going to be a problem. But the next step is, you would come to me, and then as part of my service, I would do a search of the government registry database, and then I would give you what I believe are risks from there.
How do you check whether the brand name have found is appropriate? But actually, you already answered this one, I guess.
Yeah.
The Google search is fine. We normally recommend like USPTO search, and we just go and just type the name. But you're saying that not enough, I guess, right?
The issue with doing a USPTO search is that for conflicts, the standard is confusingly similar. And what that actually means is there's pages and pages of federal regulations as to what they mean when they say confusingly similar. So unless you really know how to understand the result, you can do a USPTO search and you can provide its test2.uspto.gov. If you find an exact match, the same term, clothing versus clothing, yeah, that's going to be a risk. The problem is that a lot of people don't realize that even if there are no exact matches, there might still be a serious risk. Because let's say, to come back to my example, I had the example for towels, Sun City. So let's say you want to do Sun City for towels. City of the Sun for towels would be a serious risk, even though it's not exactly the same. So if you do an exact search through the USPTO system for Sun City, you might get 0 results. But that doesn't mean there is 0 risk. Similarly, let's say you do Sun City, an exact match search, and you get Sun City. But let's say you get Sun City for cell phone accessories. Well, that's not going to be a problem because your products are towels. So you can be misled unless you have a bit more experience in searches. So somebody who's a more advanced user who maybe has filed many trademarks before it might be easier for them. But for somebody who is a first timer, well, again, a search is a major part of the service that I provide. And in my opinion, it's the most valuable part of the service that I provide is the search and the analysis. But I feel like for somebody who is just starting, really Google is good, and as well as just Amazon, Google, see what brands are out there and then you can also see, okay, well, is this brand selling similar products to me? Or is it totally different? Because you would see the results of the exact products that they're selling.
How does USPTO determine if 2 trademarks are too similar to coexist? I mean, like, there's some character similarities or something like that.
So the standard is called confusing similarity. And there are many, many rules about this. But the simplest way to think about it is that when the USPTO looks at a trademark, they look at what they call dominant terms. So dominant terms are the parts of the trademark that do not directly describe what the product is. So to come back to my example, let's say you are selling towels, and let's say your trademark is Sun City Towels. The word towels is describing the product. It's generic. So that part is not really going to be looked at. So the 2 dominant elements in that example would be sun and city, because you're not literally referring to, a city on the sun or anything like that. It's just an idea that you came up with. They're going to then look at those and they're going to see, okay, are there other trademarks that combine the word sun and the word city for products that are related to towels? So it might be towels themselves, but it's not necessarily going to be limited just to towels. It might be, beachwear, beach hats, swimsuit could be considered related to towels, potentially even something like sunblock, though that's less likely. So they're going to be looking at similar products, similar combinations of dominant elements. So, and those dominant elements could come in a different order. So you could have City of the Sun could still be considered similar because it has those 2 main elements, city and sun. They're in the same trademark. If the products are sufficiently close, could be a problem. If the products are not sufficiently close, then it won't be a problem. And it can be a little bit subjective as to what is or is not close. And in general, when we are talking about trademark risks, frequently it's hard to say, with absolute certainty, this is a problem or this is not a problem. But rather it's something more like, well, it's a risk. There's maybe a 50-50 chance of refusal, or maybe there's a 2/3 chance of refusal or a 1/3 chance of refusal. But it's always up to the client. If they really, really like an idea, and let's say they are told there's a 2/3 chance of refusal, it's up to them. If they want to take that risk, it's possible sometimes, you get that lucky 1/3 and goes through, or it comes back with the rejection, and we can file an argument to appeal the rejection, and the rejection can get lifted. So it's just a question of higher or lower risk. But that's how that decision is made by the USPTO. And this is also, again, why having a search done by a professional is really important, because if you have somebody who has been doing this and who has done hundreds and hundreds of searches and knows how to interpret the results, that's very valuable, because just looking at results as raw data can be very overwhelming if you don't know what may or may not now be considered similar dominant elements or similar products.
What are your recommendations for reduce the risk of rejection?
You want something original. When you're looking at a certain product, there might be certain words that you want to base it on. For example, let's say for clothing, you might want something like, beautiful fashion, right? Because you want to get across the idea that your clothing is beautiful and it's fashionable. However, with terms like that, it's very likely that that's already featured in many other trademarks, because you're probably not the first person that wants to call their clothing beautiful or fashionable.
Yeah.
So it's important to include elements that you think other people probably haven't thought of. Again, very commonly people do things with their names. It's not always necessarily just the person's name. Oftentimes people combine parts of their names together or parts of their names with words, because that's obviously more likely to be original, because not everyone has the same name. Other people can do words in other languages, though this can be risky because, and this is also an important point, that when the USPTO does their search, they will translate words that are in other languages. And if, for example, you call your trademark, beautiful fashion in Turkish, well, if that's literally those words and the literal translation from Turkish is beautiful fashion, that will still have a problem, because they're going to say, well, but what about Turkish-speaking consumers are going to translate it and it's going to mean the same thing to them as the English would mean. However, you can do things that are, maybe references or idioms that even when translated would not have direct meaning, especially in the US, to make it more original. But it's important. You can still include words like beautiful, fashionable, things like that. But it's important that at least something in there be original and be something that you think it's unlikely other people have already thought of. But of course, again, the search is very important. The search will help you with that. But if you start out with terms that are very common for the product, and it's usually common sense, generally what those would be, there's probably going to be an issue. So it's good to start from a point where you think you've come up with something that is unique.
Some of our clients like to, just start the trademark in Turkey and brand register in Amazon, then they would like to transfer it over the US. So how does this process work?
So normally to file in the United States, you need to, and to get your registration in the United States, you need to show what's called use in commerce, which means selling your products to US consumers. And the fastest way to normally do this is to have your point of sale in the United States before you file. So you open your Amazon account, for an Amazon seller, you would put up your listings for your products, you would sell, and then you would file based on that. However, if you are a Turkish citizen or a Turkish business that is organized in Turkey, and you get a trademark application or registration in Turkey first, there is an international treaty that we can use to establish your U.S. filing basis. So instead of having to show your U.S. point of sale and your U.S. listing prior to filing, we can actually use your Turkish rights for that. If you just have a Turkish application, but it hasn't fully registered yet in Turkey, we can still file, and we would provide the U.S. government with your Turkish application number and application date, and we would file, and it would proceed, it would be examined, and then it will be suspended while your Turkish application is pending. As soon as you receive your Turkish registration certificate, you would need to provide me with one, full copy of your Turkish registration certificate in Turkish, and two, a fully translated copy of your Turkish registration certificate signed by the translator. So I need both. I need the original Turkish in full, and I need the full translation signed by the translator. With those two documents, I would then file those with the U.S. government, and they would take the place of your normal commercial requirement in the United States. Now, keep in mind that this does not mean that you can get around U.S. conflict. So your Turkish registration is valid in Turkey, and even if you've had it for years and we file in the United States, if there's a prior similar trademark in the United States, your application might still be denied because your prior rights are in Turkey, not in the U.S. However, what this does mean is that you don't have to begin selling in the U.S. prior to filing to file under an in-use basis, and you don't have to begin selling prior to registration. So this gets around the limitations on when you have to begin selling in the U.S. to get your registration, and it can be very useful for that reason. So again, if you have a Turkish application, we can file on that, and then we update with your Turkish registration when it issues. If you already have a Turkish registration, you just send me the full Turkish registration document, the full translation that's signed by the translator, and we can use that as the filing basis is immediately.
Yeah, but the process time is the same, right? The 9 months and over, I guess.
Yes, correct. Yes, the process time is the same. So normally, when you file in the United States, there are two ways that you can file. You can file under an in-use basis, or you can file under an intent-to-use basis. So in-use basis means that you're already selling to U.S. consumers and you have made at least one sale to a U.S. address prior to filing. So this means you're, let's say you're an Amazon merchant, you have your account on Amazon, you have your listings, and you're already selling the product under your trademark, and you have made at least one sale and shipment to a U.S. address. What this means is that when you file, we would provide evidence of your U.S. Amazon listings and your sales right when we file, and that would all go and be examined in 9 months. Assuming there are no conflicts, other problems, the USPTO will accept the application and they will register in about 13 months. Now, the other way you can file is what's called an intent to use application. And this means that you have your idea. So again, let's say Sun City towels, and you have your product list. So again, say towels. So you file the idea and the product list. This proceeds to examination after 9 months like normal, and it would be examined like normal. However, you're kind of reserving your rights to the trademark, because what would happen then is you would get something called an allowance. And at that point, the government would still need to see that you've begun selling to U.S. consumers under the trademark to issue your final registration. And that secondary filing of the notice of allowance is going to increase your costs. So you can save money if you're already selling prior to filing, or if you have the Turkish rights to use the basis instead. Because what the Turkish registration does is it replaces your evidence of U.S. sales. So normally you need to provide U.S. sales or you won't get your final registration. But if you have a Turkish registration, you can file that in place of your U.S. sales. That's what the treaty does. It lets you use those rights in place of having to show U.S. sales to get a U.S. trademark.
Okay, I see. That makes a lot of sense, actually. Let's think that our trademark application is approved in US, and we would like to add another category inside of it. I have a trademark in garden category, and I would like to sell something else in baby category. Should we still have to wait 9 months or?
Yeah. So unfortunately, the way it works in the US is you cannot add product to an already pending application.
Oh.
So if you, let's say you file an application for rakes and shovels, and then you have that application and then you decide, okay, well, I want to start selling, baby bottles under the same brand. You would need to then file a second application for the baby bottles. It would be the same brand name. So whatever brand name you came up with, it can be the same, but it would be a new application, a new serial number, and it would start at the beginning and have the full wait time. Let's say that you're selling the garden rakes now and you think, okay, I might expand this into baby products. You can file in both classes at the start, and you can file the class for the baby product as intent to use. And again, so the idea is that this would proceed like normal, then this would all be on the same application. After it's examined, you would then have to start selling the baby product, show that you've begun selling them, and then it would be fully added and you would get the registration for both. But if you don't begin selling the baby product, that class would have to be dropped. And the fees that you paid for the second class would be lost in this case. So again, the idea with the intent to use is you're kind of reserving your rights to it. You're saying, okay, I might sell these baby products, think I'm going to sell baby products. I want to reserve the right to it. And that comes with an extra cost that you pay to reserve that right. But it does reserve the right so that if somebody else comes after and wants to sell baby products under a similar name, as long as your application is live, you're ahead of them in line. And then once you begin selling, you file a statement of use, you get the full registration.
Yeah, thank you for all these answers. So could you please tell us more about you and your company? How could people can reach you, and which service do you provide actually?
My name is Anton, and I am the principal attorney of Trademark Garden PLLC, based in Arizona in the United States. I provide many trademark services and especially specialize in providing trademark services to international clients. So that's great for many of your viewers. And my website is www.trademarkgarden.com, all one word. And I can be reached directly at Anton, that's ANTON, at trademarkgarden.com, or the general website email is info@trademarkgarden.com. And I can help you with anything from filing U.S. trademarks. If you already have an application application that received an office action, so a refusal from the government, I can help you with responding to that and with seeing if it's an issue we can respond to in the first place, and then if we can, pricing out how much that response would be and filing the response on your behalf. I can also even help you with international trademarks, which can be done either through the Madrid protocol or filing agents that I have all over the world. So I offer a wide variety of trademark services, and I've done hundreds and hundreds of successful registrations for Amazon stores and for various e-commerce. And I do a lot of work for international e-commerce, both based on existing international trademark rights and U.S. sales. So any of that I can help you with. You reach out, explain to me what trademark what your brand name that you're looking at, and give me a list of products. I can most likely provide you a quote based on that, and then we can proceed. And if you can give me links to your existing listings, that's even better. If you don't have existing listings, just tell me the product. I do prefer, a lot of people will give me a category. It's better in the US if you have specific products, but even if it's a category, let me know, and I'll probably be able to quote you or at least tell you, if you need to get more specific, how you need to do that. And then from there, we can proceed, and I can do the entire process for you, from the search, issue review, risk analysis, putting the application together, submitting it, and representing you before the U.S. Patent and Trademark Office.
Perfect. Thank you so much for everything, Anton. Your links will be in description below, I guess. See you later soon.
See you, and I hope your boss feels better.
Yeah, hopefully. So,
Onur ve Anton'a çok teşekkür ediyoruz. Trademark Garden'a ulaşmak istiyorsanız web sitesi açıklamalarda görebilirsiniz. Sorularınız varsa bu videonun altına bırakabilirsiniz. Cevaplamaya çalışacağız. Özellikle Onur cevaplamaya çalışır muhtemelen. Çünkü bu konuda kendini oldukça geliştirdi. Ve unutmadan
Like'ları ve abone olmayı unutmayalım. Çünkü gerçekten çok emek veriyoruz. Bakın o kadar uğraştım bunu yapabilmek için.
Bunu 5 kayıttır yapmaya çalışıyor. Umarım olmuştur bu arada. O beğen butonunu kullanın lütfen arkadaşlar.
Evet, lütfen. Arkadaşlarınıza da atmayı unutmayın. Bu işler paylaştıkça çoğalıyor. Ben Cem Toprak.